Talking to Tamara Levy today, which is very cool and exciting. And she is the director of the Innocence Project, which is out of the Peter Allard School of Law at UBC. And we want to hear about the project, about prisons. We're going to ask you a bunch of questions. So tell us about the project.
So the UBC Innocence Project is one of a network of organizations around the world that does investigations into claims of wrongful conviction. And our small little project at the law school is run as a legal clinic. So law students work with pro bono, so free of charge lawyers in the community to investigate claims that are in BC. So crimes that occurred in BC. And to be eligible, people have to be claiming factual innocence, that they were not the ones that committed the crime, versus a legal defense, which might otherwise be a defense, but they're not cases that we look at for like a charter defense or some other kind of legal defense. We only look at cases where people say, I wasn't there, or I didn't do it, or there are many cases of wrongful conviction where the death was accidental versus intentional. So we review those claims, and people also have to have exhausted their appeals. So we get a number of calls from people who are just convicted and they're upset with their conviction, and we have to say you have to go through the appeal process, or at least have tried to go through the appeal process before you can come to us. Because that's one of the requirements for the Minister of Justice that you apply to. So it's a particular section of the criminal code that allows for conviction review by the Minister of Justice. And there are a bunch of requirements, a lot of documentation required, and it's a last resort for people who claim to be innocent of the crimes for which they were convicted.
And these are, just to be super clear for the people watching, it's for people convicted of murder or sexual assault, correct?
Yes, then that's, there are many, in fact, people suspect there are more wrongful convictions of in the lesser crimes, but because of funding, and limited funding, we focus our work on cases of the most serious offenses where people are serving the longest prison sentences, which are mostly for murder. So all of our cases at the moment are homicide cases.
And it's uniquely because in British Columbia, that's it.
Yeah, we just focus on British Columbia. Our funding is entirely external, so it comes from part of our funding, I guess maybe about close to half comes from the Law Foundation of British Columbia, and then all of the other funding we have to scrounge up every year. And that funding pays for, reports from experts and DNA testing if we can get our hands on any biological samples, pays for just disbursements if lawyers are out of pocket for photocopying or whatever it is that they need, travel, etc. for experts if we need somebody interviewed. So yeah, all of our funding goes towards those costs.
How many do you work on a year?
We consistently have approximately 20 cases, and that sort of fluctuates. We maybe close a couple and open a few more, but contrary to what people believe, once people go to prison for crimes, it is not in their interest to maintain their innocence. And in fact, we have a number of applicants, as we call them, applicants up until the time that we sort of fully take on their case, that have been in prison a lot longer than their sentence. So the worst of those cases is a fellow who received a sentence of life 10, which means he was eligible to apply for parole at 10 years. And he is still, he's now on bail, but he is under the prison authorities after 36 years. So he went into prison when he was a 17-year-old young man, and he's now 53, 54. And where we have his case in front of the BC Court of Appeal in an attempt to withdraw a guilty plea that he entered at that young age to a crime that we think he didn't commit.
Wow, that's heavy.
It's always interesting. The work is always interesting, and the inmates that we work with are always so grateful for the help. Just people that are listening to them, the students who really care about justice and want to make sure that justice has been served. And when we do our orientation with students, there's absolutely no, I explain to them very clearly that not all of these people that have applied, or not everybody that claims to be innocent is actually innocent. There are reasons that people might claim to be innocent when they're not, but there have been so many cases around the world where people have been found to be innocent after they've been in prison a long time, that we try to leave no stone unturned. And we just try to really look at every single aspect of the case where things could have gone wrong.
I guess
and every year is different, but of 20 cases a year, how many of these prisoners end up actually getting out?
Well, so these cases on average take anywhere from 8 to 12 years and up to 20 years to resolve. So it's not like every year somebody gets out. So we have some cases that we've been working on for a decade. And one of those is the one that's before the Court of Appeal right now. And sometimes in these cases you're having to allege police misconduct or Crown misconduct, or sometimes defense counsel, ineffective assistance of defense counsel. And those are not allegations that we want to be making lightly. We want to make sure that if people are coming to us saying that such and such happened, that we're not just initiating an application based on their word, that we have some other evidence to support that, or else we're not going to get very far at all. So the cases take a long, long time, and part of the challenge is collecting information. So we have two cases, one case from 1976, one from 1978, and putting together a file that old to figure out what defense counsel had at the time, and were there problems with disclosure, is next to impossible, but we try. And freedom of information is difficult in Canada, and the ministerial application allows for the lawyers that work for the Department of Justice. They have powers that they can order disclosure from the provincial Crown or the police, but as advocates for a person applying to the minister, we don't have that power. So sometimes if there's just no way we think we're going to get a hold of information, we'll in our application just flag for the lawyers at the minister's office, which they're called the Criminal Convictions Review Group. We just flag for them, look, we think this this witness might have important information. Perhaps you might try getting a hold of this individual, or we think in the Crown file there might be this information. Could you look? When we don't think we can get a hold of it. But one of the requirements, or the major requirement in going to the minister, is that you have to have new and significant evidence. So it's not intended, this process is not intended to be a further appeal. It's intended to bring to the attention of the minister something new. So you can't just re-argue issues that were before the trier of fact. So sometimes the information was in the file, but it was missed for whatever reason, either by the defense lawyer or perhaps it was never disclosed. We have sort of both of those situations in our cases. And for that reason, even though it was there, it wasn't before the court and considered. And so we have to explain how that happened and unfolded and why this information might be important. And sometimes the information is completely new. It's a witness that that has either come forward or that we found through our investigation that said, yeah, I was across the street and the police, I talked to the police and told them I saw what happened, but they didn't interview me. And really, so
like in those cases that you've resolved, and I'm sure it's feels like a significant win for you and your team and the folks working on these cases. Does it, out of like those 20 cases, how many times have there been missed information in scenarios like you've just described? They've missed the information or something critical? Or
yeah, in almost every one, there's something that was missed by somebody along the way, and it's understandable. I mean, even former Chief Justice McLaughlin talks about these cases when she was giving a lecture to other judges. She said, criminal justice is a human endeavor. And because it's a human endeavor, there are bound to be mistakes because people make mistakes. And, I not for a minute do I think that it is always intentional. It is just human error. The witnesses make mistakes. They sometimes are eager to help and want to do the right thing. Maybe they're persuaded or police have been known to, unintentionally contaminate witness statements by sort of dropping in a fact that they know, but the witness doesn't, and the witness works that into their telling of the story, or even with accused people and confessions. And we now know confessions can be false, and eyewitness identification can be wrong. In fact, it's in the States the leading cause of wrongful convictions. So lots can go wrong in a criminal trial. There's just so many moving parts and so many people involved and so many decisions that have to be made. Some of them have to be made quickly, either in the investigation or in the defense or in the prosecution. And so things can go wrong along the way. And our job with the students is to just really take a long and very close look at the file that a lawyer working on legal aid at the time with 50,000 other things to do may not have had the luxury of doing. And it's incredibly educational for the students because they get to really look at a file in a way that they probably won't get an opportunity to look at again, but at least they'll know what that process looks like and the level of detail that they have to sort of put towards a file review if they want to do a really thorough job.
So you need obviously some connectivity with the person incarcerated, and now with COVID-19, what are you seeing about people who are in these in jail, and what is the concern for some of the legal aid people that are on your team?
Yeah, they're obviously concerned. We have 3 applicants in Mission Medium Institution where there was an outbreak last month. 2 of them contracted COVID, but both have recovered. That outbreak seems to be contained because as of on the Corrections Canada website this morning, there's only 1 active case currently, but there were about 150 or something like that. And they were nervous, and one of our applicants who was in a minimum security prison, he received parole just a few days ago, a day parole, because, well, for a lot of reasons. He was a model inmate and had successfully been out in the community on many sort of temporary absences, but partially as well because he has a very serious health condition, and COVID posed a great threat to him. So the supervising lawyer on his innocence claim stepped in and wrote a letter to the parole board. And I don't think that was the only reason that he got parole, but I hope that it helped. And so he's been granted parole, and he has also been granted 30 days. In 30-day intervals, he can be with his family, in a supervised fashion.